is a part heard accruing a matter of Warwickshire Borough Council and Secretary of State for Transport and another.
Yes, Mr. Strong.
My lords, my lady, there's a bit of homework from overnight, if I could just explain.
We've had brief overnight gifts from the appellant side in the form of a note on remedy. Maybe just that, actually.
I think that.
And you'll get.
My lord, I'm going to.
Stuff as well.
We've divided the labour a little, so I'm going to hand in, if it's convenient, a copy on the note a copy of a note on the hybrid bill process as far as EIA is concerned. And if I could just hand it up. At the same time, I'm going to hand up the index to the Act.
Yes.
Which is they're separate packs. And I'll just explain, if I may do so very briefly, what we've given you. I think on the top you may have a copy of the index to the Act, and it may be that could just be slotted in to the authorities bundle at tab 3.
Yes.
Apologies, we've stapled it. It's probably unnecessary.
Right.
And then the other document I've handed up is a short note. I say short because, in fact, we've included a quotation from the Supreme Court's decision in the HS2 Action Alliance case of 2014, which summarises the hybrid bill procedure and also draws attention to the relevant standing orders, and that's in the judgment of Lord Carnworth. And we hope that is, I hope the summary I gave to you yesterday is broadly in accordance with that, save for one point, that in the course of my submissions yesterday I referred to the environmental impact assessment process being dealt with by the Environmental Audit Committee. And I was wrong about that. It's an examiner of the House that takes responsibility for that. And as part of that process, appoints an independent assessor of the ES to consider the ES and representations received. But then, as I previously indicated, there is a report back to Parliament, in effect. So this is a separate process to the hybrid bill petitioning process. And we hope this is helpful. Attached to the note, depending on your degree of interest in the detail, there is an information paper B5 which summarises the EIA process, although you've now got the other documents. The second yellow sticker is at tab 2 is the standing orders from the House of Commons and the House of Lords, to which references made in the judgment. Save at this point, these are the versions from 2017 and 2018, because we haven't in the time been able to locate the ones which are dated 2014 referred to in the judgment. We don't think they're changes, but I just want to point that out. But we haven't, it's not readily available, the previous version, but we don't think there are any material changes. And then you should have, after the standing orders, the case of HS2 Action Alliance itself, again, insofar as you want to.
Yeah, what would be helpful would be to have identified which of the passages which deal with public participation.
My lord, those are in the note.
I'm just looking at the note. And
it's really 57 through to 60 is explaining. So the hybrid bill procedure is the point I was making yesterday about the difference.
Yeah,
and then and then the 59 and 60 is really dealing with the standing orders. and it's really paragraph 60. You're right, my lord, we could probably do better in terms of explaining. Yes, my lord.
I'm flicking through, I can see reference to it, but
your lordship's right.
We'll just add a few references, that would be much appreciated.
Certainly. I think it will be, we can flag up those paragraphs in the standing order which cover that representation procedure.
But is it dealt with in the Supreme Court's decision?
It's only, I'm not sure it's dealt with in more detail than the paragraphs we've referred to. So if you want more detail, we'll flag up the relevant paragraphs.
Don't go wrong.
We'll try and do that in this.
I mean, it is a very specific procedure.
It is, Mum.
Yeah.
I think the one that we've attached at 224, Standing Order 224A, is probably what we'll be referring to. Well, that's the second yellow sticker, and it's page 80 of that internal document, and the procedure that's laid out there deals with the first notice of publication by the minister.
Presumably there's a procedure for what we might otherwise call statutory consultees to have their two penny worth as well.
My lord, as I understand it, it's dealt with as the ability for anyone to comment. I haven't noticed the distinction.
Okay.
I might be wrong about that, but
thank you.
now I hope that helps. There is another piece of homework which, as I say, Division of Labour, my learned friends have generated. We've seen and agreed, but I understand the appellants haven't had an opportunity to look through that. So I'm not going to
don't hand in anything unless Mr. Howell, Williams and Miss Ollie have had a chance to look at it.
No, we won't, my lord. But these are the two notes on the right to be heard and the Phase 1 bill, petitioners and challenges to standing. Can I, while I'm on my feet, provide copies of two things? We were asked this morning by Lord Justice Holgate's clerk to provide copies of the letter from HS2 to the council, to the appellant, of 22nd.
Oh yes, that has reached us. That
you
I
have
couldn't. Yes.
You have printed
Thank you.
copies?
Yes.
Yes. Also, we were asked to provide copies of the sections showing difference in levels.
Just to see how it's presented,
Sure.
and it seemed that because this was referred to in oral submissions yesterday.
Yes, certainly. There is a section. There is a number of sections at.
I was afraid of that.
At divider 36.
Just one would do.
Yes. Well, we've got one. We've got one. But whereas you may have it in your bundles in A4 form, we've copied them in A3.
Thank you.
Which is easier to read.
Yes.
So this is page 320. I'm afraid we haven't had time to hole punch them.
Well, it's very helpful.
Thank you very much. Two copies. Yes.
with your permission, my lord, I'll press on and see if I can
please
complete my submissions relatively speedily. I took you yesterday to some of the factual material and the environmental screening report. Could I just give you, we can go to them if necessary, but some references to help you with the facts. The reason for the change, as far as the interested party was concerned, and the nature of the change is described in more detail in Mr. Gilfedder's witness statement, sections 8 to 10, supplementary bundle, tab 2, pages 29 to 36. And some of that is set out in the executive summary of the screening report to which I referred yesterday, pages 161 to 167. But in more detail in the body of the report, paragraphs 2.27 to 2.37, beginning at page 191. And I don't think I gave you the conclusion of the screening report that there were no new or different significant effects caused by the proposed development, but you'll see that, for example, at paragraph 19.1.17 at page 215. Now, the court's seen some of the correspondence that began with the screening report between the interested party and the department in relation to a Transport and Works Act order and the potential need for that. I wasn't proposing to take the court back to that, other than just to summarise briefly what happened and to add in the letter by way of context that you asked for and received today. In short, the screening report, which I took you to yesterday, was carried out, I think, in February 2021. That was then considered by the council, who issued its own screening opinion on the 10th of March 2021, see page 219, concurring in the view that there were no new or different likely adverse significant environmental impacts. I'll come to whether that's the right test in a moment. Then you had the screening decision on the 31st of March 2021, page 225 to 227. And you've been taken to that on a number of occasions, so I'm not going to take you back to that. That's the one where it was acknowledged no new or different significant effects, but changes to the projects were being proposed by the Transport and Works Act order, so a EIA required. If one then interposes at that point the letter that you requested, dated June 2021, that I hope is relatively self-explanatory in explaining in terms the position then taken of HS2 as to whether or not the works did require planning permission or whether they were covered by Section 2 subject to the Section 20 test. And you can see the view then being expressed.
Yes, when I said it reached us at about 10:26.
So
don't assume that we read it. So.
Well, I wasn't proposing, well, my lord, if your lordship has it there.
Yes.
If I endeavour to summarise it, it's effectively dealing with the fact that the screening assessment that I took you to previously was put on the basis of an assumption that planning permission would be required. And that then resulted in the screening decision from the Secretary of State. This letter...
Say that again. This letter was on the assumption that...
No, the original screening...
Oh, sorry.
The screening report that I took you to yesterday was on the assumption that planning permission was required. That led to the screening decision. And HS2 and its lawyers then, and you can see this referred to in the letter, took the view, in fact, the works were authorised under Section 2 and consequently would benefit from planning permission subject to the Section 22 test, which is then addressed in terms in this letter. And that explains why their position, this is written to the council at the time. So, and that's referred to in the inspector's report. And then to further by way of factual background, on the 20th of October 2021, the interested parties solicitors wrote again to the Secretary of State about the Transport and Works Act order under its then position that in fact they weren't seeking planning permission and therefore an EIA was not required because the order wasn't seeking approval for works. Their position was they're already authorised in Section 2. And that then led to the...
Sorry, what was the reference for that?
Sorry, that's page 231 to 236 of the supplementary bundle. And that yielded the response from the Secretary of State for Transport of the 4th of November 2021 at pages 237 to 239, to which you went yesterday.
Sorry,
237 to 239, pages 237 to 239. And the court went to that yesterday with my learned friends submissions, and there was some exchange about, well, what was the Secretary of State expressing a formal view or not, and so I just leave it. In my submission, the letter speaks for itself. It's leaving it up to, in effect, HS2, if it's not proposing works, not to put in an EIA, but if it is, to put in an EIA or an ES. And then the draft TWAO, that's a Transport and Works Act order, in light of the interested parties' position, I think was submitted on the 20th of January 2022. And of course, in line with the explanations you've seen from H2, did not include an ES. And you can see that expressed in relation to the statement of aims that is a document required for a Transport and Works Act order application, paragraph 3.5 on page 253 of the bundle.
Noticing at 241, when the application for the order is made, paragraph 3, the effect of the amendment would be to remove a legal impediment to a small part of the row that being constructed within the tunnel. The impediment being that the Schedule 1 work was for a viaduct.
The schedule,
That's what this is saying.
that's what the view was, treating the reference to 30 metres on, well, viaduct, which was 30 metres, to be a legal impediment. Whether or not it is, my lord, I'm not going to enter into that debate. I'm just dealing with the question that arises under ground 2. So I wasn't proposing to say much more about that because, in a sense, that exchange of correspondence doesn't necessarily answer, but perhaps just begs the question that when the Secretaries of State make their decision on the Schedule 17 application, to which I'm coming, they applied the right test. But the Schedule 17 application was made on the 22nd of September 2021, which you can get from the subsequent report.
22nd of
September 2021.
Thank you.
And that application covered a number of things, but not a tunnel, i.e. not the tunnel extension itself, on the basis that that was not a building work under the 2017 Act.
Is that explained somewhere?
In the application, I'm not sure it is, but it's the
Somewhere else?
it's explained in Schedule 17.
No, but
The definition.
is that reason put forward somewhere?
My lord, I'll have to check. I don't know.
Because my recollection is that this was an application, as you say, for a number of works, pursuant in part to paragraph 2 and in part to paragraph 3
My lord, yes.
of Schedule 17.
Yes.
Paragraph 3 of Schedule 17 is not building works, it's other construction works.
Indeed.
So I can understand the point, I do understand the point, that tunnel is not a building, doesn't fall within paragraph 2, but paragraph 3 covers earthworks. Would it not cover a tunnel?
No, my
Why
lord.
is that?
Well, a tunnel is obviously not a building work, but a tunnel, an earthwork, as I understand it, is, for example, the creation of an embankment, otherwise known as embankment, or some large bund or something of that kind, rather than, as in the case of a tunnelling work, the extraction of soil. I think it's going to the methodology, but by slurry treatment and then removal of that. And certainly...
But if that be right, so after you.
No, certainly that's my understanding of it. And the other point I'd make about the question of whether or not anything else required Schedule 17 approval is I don't know what other approvals were sought or were not sought, other than I do know that, for example, the tunnel portal building was the subject of a separate application. And if your lordship's concerned that there may have been the need for the tunnelling itself to be the subject of the Schedule 17 application, I don't know even if that occurred or not. But no one's taken a point.
No,
and
it's
it's not a
trying
point
to
of this.
understand the statutory framework. Because if it be right that tunnel doesn't fall within paragraph 3 of Schedule 17, it doesn't look as if tunnel falls within Schedule 17 at all.
My lord, that's what I understood to
But
be.
if that be right, it means that there is no if you take a tunnel as a Schedule 1 work, 20% of the project,
Yes.
that isn't subject to the conditions introduced by subsection 3 of section 20.
My lord, that would be right.
Which seems astonishing.
Well, not necessarily. It wouldn't be astonishing in this respect. Schedule 17, for example, in relation to building works, is dealing with principally plans and specifications for things above ground, because the authority could be deemed to have an interest in, say, the final appearance of a bridge, a tunnel portal building. So far as an underground tunnel is concerned, the structure of it, that's not something that would naturally require or necessarily Parliament would think necessary for a local authority to have Schedule 17 approval over. Insofar as there are other things that occur as a result of activity, namely construction activity, there are other approvals that are obtained, class approvals such as lighting of work sites, transport movements on the road network. So, my lord, I take your point that construction activity may, insofar as it has effects on the wider environment, be the subject of approvals, but not the actual tunnel, for example, in relation to its appearance. So I would submit that that's not surprising, in fact. But there are a whole other range of other approvals necessary to carry out the construction.
But it's in the context that if you're talking about a Schedule 1 tunnel, its position can move vertically.
Yes.
With there being no limits of deviation.
My lord, yes. And it may well, moving it vertically downwards, in fact, it can only go down.
Yes.
Well, it can go 3 metres up, but down.
3 metres above ground? Or
no,
3 metres up?
3 metres up from its levels. I think that's right. Yes. But my lord, that, as I would submit, is not surprising at all, because putting a tunnel further down into the ground doesn't have the material, so far as impact on users above. insofar
I
as
was
it...
just wondering about the dispute which ended up in the High Court over the tunnelling by the Euston Throttle, or whatever it's called.
That, my lord, that was a very large, well, if one's travelled into Euston, it's the very large cutting into Euston,
Yeah.
for which there's a very large retaining wall.
Yes.
And the structure necessary to allow the necessary tunnels raises an issue about the
Is
stability.
that the subject of a Schedule 17 application?
My lord, but not because it's a tunnel, but because
Okay.
I think because it involves a combination of retained cuts.
Structural walls.
Indeed. And the issue related to the stability of that, and a lot of it to expert evidence.
Okay. Thank you.
So well, I hope that assists. But so the Schedule 17 application was then made on the 22nd of September. You've been to paragraph 30 of Schedule 17, so I won't take you back to that, which was the exclusion of a tunnel, but we just discussed that. On the 8th of October, the Council declined to determine that application. See page 228. And that led to the appeal. And then you've got and seen, I'm not going to take you back to the inspector's report of the 31st of March 2023, core bundle, tab 11, page 146. And then the addendum report on the 13th of December 2023, core bundle 12, page 175 to 184. And the reason, I hope it's clear, for the need for an addendum report is that because the inspector had taken the view these weren't authorised works, he didn't go on to consider whether or not the works were acceptable for the purposes of Schedule 17. But the Secretaries of State asked the inspector to report on that issue, no doubt anticipating they took a different view, or might take a different view on the legal position, and therefore wanted to know, assuming it is authorised, are the works otherwise acceptable? And that's, in effect, what the addendum report deals with. And that then, of course, leads to the Secretary of State's, the two Secretaries of State decision that you've got in your bundle at tab 10, core bundle, tab 10, page 138. And I'm not going to go over the ground one issue, of course, as that's covered in the decision. So far as ground two is concerned, that's really covered from paragraph 11 in the core bundle. And I had drawn the court's attention yesterday, in particular, to paragraph 13. And you'll see the reason I had been taking you to the screen report is because part of the material before the Secretary of State, and to which they referred in reaching their decision, was indeed the screening report of February 2021.
You just gave a reference to the pleaded defence.
No, so, my lord, sorry, core bundle tab 10, it's paragraph 13 of that document. I apologise. It's page 141. Of the core bundle, it should be there.
Yes.
And so I've tried to deal with it chronologically, but you can see there's a reference back to the report that we were discussing yesterday, which the court doesn't have in full, but explains the basis for the conclusions. And if I can try and distill things now as to the issue before the court, there is no, as we now know, categorically, rationality challenge to the Secretary of State's decision that in this case there are no new or different likely significant effects arising from what is proposed as opposed to what was previously proposed. And there is as part of that, no challenge of the sort of type you might get, which is, well, failure to take into account a relevant impact or something of that kind. Indeed, there's no criticism of the analysis in the screening report in and of itself. And therefore, the issue before the court necessarily is, have the Secretary of State misdirected themselves in looking at that question, namely whether the proposed development gives rise to new or different likely significant effects to those already assessed for the original development. I believe that's really what it distills down to.
Yes.
And for the reasons I'm just briefly going to explain, we submit no error. Indeed, that's what properly interpreted the Act requires. In that respect, we commend to you the judge's analysis below of paragraphs 43 to 63, core bundle, page 47, or tab 6, if you have it separately. And perhaps unsurprisingly, as a respondent here, I do rely upon the reasoning, and we do submit it's entirely correct. But I'm just going to highlight why we say it's correct, if it's convenient to do so. First of all, I took you yesterday to the Hirachand case, but the judge doesn't refer to that principle of this, assuming Parliament understood the legislation, but it's clear it's in the application of the judgment at paragraph 45 and 48, because the judge is referring, particularly at 48, to what Parliament would have known about how EIA works and what is its purpose. And that then, of course, begs the question, well, has the judge correctly understood the purpose to which reference is being made? We say absolutely. But can I then address that by reference to the EIA regulations that you went to yesterday?
Are you going to define for us in a moment what the purpose is?
My Lord, yes.
Yeah, okay. And the purpose of section 20?
Well, I'm going to start, if it's convenient, with the prohibition that's expressed in Regulation 3 of the Environmental Impact Assessment Regulations, because that is getting at the very purpose of EIA, and that's on page 92 of the bundle.
By the way,
of the bundle of authorities.
We've got the 2017 regulations.
My Lord, yes.
Came into force, I forget when, sometime in 2017. But the section 68.4 text asks whether, in relation to the development, there was information fulfilling the requirements in the deposited statements, fulfilling the requirements of an environmental statement, which would be the regulations at the time.
My Lord, you're absolutely right. And
I mean,
I'm not.
It would be helpful just to know what, because I noticed that the DTP's letter, which you referred to a moment ago, in March, wasn't it, 2021, referred to the EIA directive on the basis of the Transport and Works Order regulations of 2006, which in turn referred to the directive. I mean, which legislation should we be looking at?
Well, as a matter of principle, you should be looking at the regulations or the relevant parts of the regulations in force at the time for the Act.
Yeah.
And
so
rather
that would be helpful as well, rather than
my Lord, yes,
scrabbling around for it afterwards.
And
would it be the regulations, the general regulations, not necessarily the Transport Works Order regulations?
No, it would be, because I think the way the standing orders that I handed in earlier, and indeed the reference to the environmental statement, that are intended to reflect I'll just check that actually.
They're basically.
They are, for the present purposes, I think there's no material difference. Sorry, sorry.
Will you forgive me?
Yeah.
2017.
68 1. And it's here.
Yes.
Because
it's
the
the
2017 regulations reflect an amending EC directive in 2014. I have no idea whether that makes a difference.
My Lord, you're absolutely right. The Act itself refers to the 2011 regulations, which were the preceding ones, I think, to the 2017.
Where does the Act refer to the
In
interpretation?
section 68.
Thank you.
I'm grateful to my learned friend.
Thank you very much. Well, could we have a copy of those, please?
Yes, indeed. My Lord, and doing the best I can now,
yes.
I'm pretty confident.
There's not much difference.
No difference so far as
It's
this.
the umbrella principle. If you don't look at them, there's bound to be a difference.
Well, subject to that, I'm pretty confident in my own mind as to what the amendments were, that they're not bearing upon this question.
Yeah.
Which is, well, what is the purpose of the regulations,
yeah.
and what is the key operative parts of it. And so I hope I can proceed at least by referring to the 2017 version, but I will identify any differences in the 2011.
Well, I'm speaking for myself. I would like to have a copy of the 2011 regulations.
Of course, my Lord, no, but for present purposes,
yes,
if I make the submissions
yeah.
now, I will certainly provide the 2011 regulation. We'll get them. Thank you. But Regulation 3 was the one I was seeking to take your worship to page 92 of the Bundle of Authorities, tab 4. And that is the prohibition on granting planning permission for EIA development unless an EIA has been carried out. That begs the question, well, what is EIA development and EIA? Those are defined in Regulation 2 in the definition section. And again, I don't think any of this has changed. Page 88. EIA development, of course, can either be Schedule 1 or Schedule 2 development. For present purposes, there's no dispute that the construction of a line for long-distance railway traffic is a Schedule 1 development. See paragraph 7 of Schedule 1 at page 171. As to what is EIA, the definition takes you then to Regulation 4, and that's on page 92, and that sets out, as was discussed yesterday, a process consisting of the preparation of an environmental statement, then consultation, and then steps required of the decision maker, in this case Parliament, under Regulation 26. And we've now given you the standing orders which seek to reflect that in the parliamentary process. My Lord, I appreciate you haven't had a chance to read that note and the standing orders, but that's subsequent process.
It's helpful just to underline that environmental statement is a document which is at the outset of the process.
My Lord, yes.
It's not to confuse with EIA, which is the totality of the process.
My Lord, absolutely, and of course EIA, the scrutiny of the required by the decision maker takes into account environmental information,
yes.
which is defined as both the ES and, of course, representations received about the environmental
and any
statement.
further information the decision maker requires.
Indeed.
Yeah.
And so, absolutely, my Lord, we fully accept that. And then, as to what an environmental statement is, as referred to in Regulation 4, you go back again to Regulation 2 on page 88, but that then takes you back to Regulation 18. So I'm just giving you the full route map. But Regulation 18.1 then defines what an environmental statement must comprise. And it is, under 18.3, at least a description of the proposed development, comprising information on site, design, size, and other relevant features, And then B, a description of the likely significant effects of the proposed development on the environment. And then measures to offset, reasonable alternatives, a non-technical summary, and any additional information under Schedule 4. And Schedule 4, again, if you want to look at it, it's at page 183, much further on, but that sets out other potential requirements depending on the nature of the development for an environmental statement. All of this is directed at, and always has been directed at, the identification or assessment of likely significant effects of the development before consent is given, and the scrutiny thereof. That's essentially the purpose of EIA.
Maybe we should look at page 99 of this internal vaccination of this tab 4, because you mentioned Schedule 4, paragraph 5 gives further detail of the likely significant effects that should be assessed. Without reading it down.
My lord, sorry, I just missed the page 99, did you say?
Yes, at the bottom of the...
Oh, sorry, internal, yes.
Internal.
I'm so sorry. I just looked at it wrong. Absolutely, my lord, yes.
And maybe paragraph 4 as well.
My lord, yes. There are very obviously a wide range of topics that can, and
These
some
definitions are slightly overlapping, but reading them as a whole, it's quite wide.
it is wide, and it also makes clear it covers both construction and operation, for example. So the topics are all set out. There are then evaluative judgments as to which topics actually need to be included, depending upon the characteristics of the development. And then obviously judgments about what, if any, the likely significant effects are, although Finch in the Supreme Court establishes now that whether something is an effect is a matter of causation law rather than evaluative judgment. But for present purposes, that I submit is not necessarily relevant here. What you do have, as I go back to the environmental screening report, was a judgment made about whether there were new or different likely significant effects arising from putting this into tunnel as opposed to having it on the surface, and the judgment reached, which no one has challenged. So, to my Lord's question, if someone considered that something under Schedule 4 had been left out of account in making that judgment, then of course you could bring a challenge on that basis, saying, well, you failed to take into account climate change, and we see many of those sorts of challenge, or you failed to understand properly how to assess climate change, or something of that kind. There is no such challenge in this case. So no one is saying that if it's right to look at whether there are new or different effects, that there's been anything omitted from what is a very full report.
It's not particularly easy to bring judicial review on the basis that a particular factor has been left out of account, because that's very much a matter for the judgment of the decision maker normally, isn't it?
My Lord,
you'd have to show that to
Wednesbury rationale.
Exactly.
Potentially.
And isn't the way the scheme is meant to work that if people think that matters have been left out of account, the EIA process is there to pick them up?
My Lord, there are two stages here. First of all, there is the original environmental statement, and that's absolutely right. In the representations on the original environmental statement, you can raise exactly that sort of thing, and judgment can be made or more information sought. Here, under the Act, Section 20, I want to come to, because that's what's an issue.
Yeah.
I'm tackling the question which the Act asks as to whether or not the works are covered by an environmental statement. And that involves an assessment, evaluative assessment, of what's in the original ES and what's proposed to see if it does indeed cover it. So, my Lord, that I submit is how we get to where we're getting to in terms of that test I posed.
And then the end of the environmental assessment process is the decision.
And then there's a decision, which in here is the enactment of the
Yes,
2017
but
Act.
seeing in terms of how we've transposed the directive, is that Regulation 26,
It is, Mark.
which is at page 38?
Yeah, exactly. And that process is the one that is covered by the standing orders. And whilst I've given you that process, as a matter of principle, observing constitutional propriety, compliance with the standing orders by Parliament in enacting the Act is a matter for Parliament rather than the court, I submit. But
Yes, but without going into that, the nuts and bolts of it is, as you were pointing out, 26.1 requires a decision maker to examine the environmental information.
Indeed.
That's the product of the ES,
Re-
all the various representations which have been made, and any further information required and provided.
Look, absolutely, and that process has been undergone before the enactment of the 2017 Act. Having now been enacted, it's established, as it were, that the grant of planning permission by the 2017 Act complies with the EIA regulations by the process that's been undergone. Or if I put it another way, that's not a matter open for debate because it's covered by effectively parliamentary privilege.
Well, that's not the subject of this challenge.
No, exactly. But we can take it as given that the original ES, well, for my purpose, the original ES in assessing the works and granting planning permission complied with the obligations under the EIA. So all these things were either looked at or looked at sufficiently. So can I then, having identified what's the purpose of the regulations, this prohibition subject to EIA, that's been gone through for the 2017 Act. What then does the
Sorry, can I slightly reformulate that and see if you agree? The purpose of the regulations is to prohibit the grant of development consent for EIA development without EIA being taken into account?
Without the process, being taken into account, I would say without the EIA process having been undergone.
Which includes taking that product, the information, into account.
My Lord.
Thank you.
That then begs, and this is, I think, quite an important point, it begs the question, the development that you mentioned a moment ago. Well, what is the development? And in this case, the development is that defined in section 20, subsection 1, page 23 of the Bundle of Authorities, tab 3B. And it should not be confused with subsidiary parts of the development. So here, the development that's granted under section 21 is planning permission deemed to be granted for the carrying out of development authorised by this Act. And subject to section 20, which we'll come on to in a moment, that therefore covers anything done under section 1, anything done under section 2, and indeed anything done under section 42 and the enactments, the 19th century enactments, for example, insofar as their works are authorised and they're carried out. And importantly, it is a development consent for the whole railway. The project is the whole railway. And indeed, there's plenty of environmental jurisprudence on the dangers of salami slicing, particularly in relation to motorway projects. You can't sort of take small sections of your line for the purposes of ES and then say, well, it's got a very small environmental impact, and then build sections and sections. Here, the project is the London to West Midlands railway line, and the works authorised by the Act. And that is the development consent granted by the Act. It's important to understand that because section then 22, subsection 2, obviously qualifies the extent of the deemed permission. Any scheduled work has the benefit of a permission, but the permission is then disapplied if the cumulative requirements under section 22 are applicable.
In relation to a work which is not a scheduled work.
Exactly.
So at this point, the statute is not talking about the railway as a whole. It's talking about a work which is not a scheduled work.
It's distinguishing, if I put it in a slightly different way, in Schedule 1, there are identified, specified works. So by definition, one knows what they are. Section 2 allows one to authorises works which may inevitably not be known at this stage. If they were known, they'd probably be in Schedule 1 in any event. But it allows, even on the council's case, roundabouts, etc. Section 2, therefore, is authorising works of that kind to occur, but the restriction in section 20, subsection 2, is to say, well, you have planning permission for all those things subject to those cumulative criteria. And that, in our submission, secures what I'm going to refer to as the environmental
But so far, in listening to you, I haven't heard where the qualification comes to the proposition I put to you. The development which is spoken of in subsection 2 is not the railway as a whole. It is the carrying out of a work which is not a scheduled work.
My Lord,
I understand your point that subsection 1 is clearly talking about the whole railway, but I'm having difficulty in understanding how subsection 2 is talking about development in that broad sense.
well, my Lord, it is recognising that the Act authorises a whole range of works, some of which aren't specified, and if you then carry out what would be an authorised work which hasn't met the criteria, then planning permission won't exist for that.
Let me approach it the same question in a slightly different way. The 3 criteria, A, B and C, as you rightly say, have to be applied cumulatively.
Yeah.
They have to be applied to the work in question.
Yes?
Yes, that's all I'm putting.
No, well, my Lord, yes,
Not the whole railway.
I understand that. I think it's important, however, to understand the concept of development in this respect. If one takes an outline planning permission, for example, for a business park,
Yes.
the permission is to build a business park. Within that, and indeed for each and every building, there are all sorts of sub-pieces of action which constitute development, including the external appearance of windows. So, in a sense, if you use the word development to describe each and every act that would fall within the description of development, you can end up with that sort of level of detail. So, all I'm identifying is that the Act itself authorises the development, the construction of the railway, which comprises a whole host of different things going on. It recognises that some works aren't actually specified as yet, and those will be authorised. You do have planning permission for those unless those cumulative criteria are specified. That's really all I'm saying. Whether that constitutes disagreement the way your lordship puts it, I don't think it does, but it...
That's gratifying.
Well, that is my submission anyway, as to how it operates. So, my Lord, those qualifications are therefore cumulative. Can I just pause there? I want to show you Rochdale shortly, but just to observe that the cumulative criteria in this case, or relevant to this case, it's not in dispute and never has been in dispute that the works around the Water Orton area that you've seen described would give rise to likely significant effects, whether they're done as the original scheme or the proposed scheme.
Could you say that again, Mr. Strong?
Sorry?
Could you say that again?
Yes, it's not in dispute, and I don't believe ever has been, that the works in the Water Orton area, I apologise if I don't get it precisely right, but the works in the Water Orton area comprising the scheme as originally proposed and as now proposed would give rise to likely significant effects.
It's not correct. No, that's your case, but Mr. Howell Williams doesn't accept it.
Well, so be it. Okay. The reason I say that is if you were to look in the screening report, as I've already explained, it identifies the likely significant effects of the original scheme, the likely significant effects of the proposed scheme, and then whether there are any different, new or different.
Both the viaduct and the tunnel have likely significant.
Indeed, my lord, it's always been
I think it's the way one puts it.
Well, my lord, I hope maybe a shorter way than I put it, but I don't understand that ever to be in dispute. What is in dispute is, on this case, is whether focusing on new or different likely significant effects is the correct approach.
Yeah.
So, 20 subsection 2A, are there likely significant effects from the works? Yes.
Can I ask you about A? A really is replicating the criteria for screening of EIA development.
Well, it does do that, but the screening are, in a sense, replicating the wider test that the EIA is concerned with.
I mean, if you answer A, yes, in terms of the 2017 regulations, or 2011 regulations, it is, quote, EIA development.
If you're seeking planning permission to do something, and your answer is likely significant effects, and it otherwise falls within Schedule 1 and Schedule 2, then there'll be a need for EIA for that.
I didn't add those words in.
I know, but if you're not seeking planning permission, and there's already a pre-existing planning permission, and you're deciding whether or not you fall within the scope of it, then it's slightly different, because you may have likely significant effects as you were previously, but you may still be in the environmental envelope of what's previously. Well, that's where C comes in, and that's why
I hadn't asked you about C.
I'm so sorry. Well, but
sticking with A.
Yes.
That's the screening test for whether development is EIA development. It's only the first stage.
Yes, just to be strictly accurate, I believe only for Schedule 2 development.
That's true.
Because Schedule 1 is automatically, regardless of.
But then, you see, you emphasised previously that this is a Schedule 1 case in relation to the railway as a whole. But when the Department of Transport in their March 2021 letter was looking at these issues, looking at the directive, they looked at the part of the schedule which is dealing with changes in a project.
My lord,
which is what this is really about.
Well, my lord, I'm looking at it from the purpose. I'm dealing with the Secretary of State's decision, which is to take Section 20, subsection 2, and to consider whether these works fall within language disapplied because of the cumulative effects of A, B, or C, and that's what I'm addressing. In a sense, I'm not.
But if you're looking at it from a purposive approach, I mean, it's not really that difficult. Annex 1 or Schedule 1 developments are things like railway stations and nuclear power stations, which self-evidently have likely significant environmental effects, such that you don't need to build a legal test in to the legislation. All that's happening here is this subsection deals with a smaller item of work than the whole project. And it simply asks, first of all, in relation to that individual item of work, does it have a likely significant environmental effect, which is the equivalent to the screening test?
Well, it is the equivalent to the screen test, but it's not answering the question of whether or not, because they're cumulative questions, whether or not. I'm sorry.
I mean, that did strike me when I read the section initially.
My lord, I'll progress in the way that I hope is helpful. If if A is met, either likely significant effects from what your proposed change, that is a necessary condition, but not a sufficient condition to remove planning permission.
Of course.
And why it's necessary, because if you didn't have any likely significant effects, you don't get past first base. If, as in this case, there are likely significant effects from the proposed change, the question still remains, well, is it still the benefit from planning permission? That is answered. B is not relevant to our case, but there are certain things which can be exempt. That is then answered by subsection C. And the question of whether or not in effect, it's covered by an environmental impact or environmental assessment with the bill. And I'll come back to those words I made in just a moment, but my Lord, can you just, and my lady, just note that it's deliberate use of language as considered by the judge, covered by, not assessed in. And the significance of that, of course, we say entirely deliberate, is that by definition, Section 2 works, for example, or non-scheduled works, won't have been specifically identified in either the bill or the ES, or the detail of them described. And therefore, you wouldn't expect them to be specifically identified and assessed in those terms. But the Act deliberately uses the words covered by because it's embodying the principle, are these environmental effects covered, as in within the scope or umbrella or the cover of the environmental assessment that's previously done, or in other words, as the judge put it, the environmental envelope. And that's why the words covered by are used, not as the council would have it, in effect assessed in, because they say, well, unless you can point to the Bromford Tunnel Extension and its portal being identified in the ES as originally put, you fail. Well, if that were right, then Section 2 and this whole flexibility that's intended would vanish, because by definition, Section 2 works aren't non-scheduled works. They're things which are occurring or it's required after the event, as it were, through the process of detailed design. And it would be curious to expect them to be set out in the ES in that way. But the question is, are they covered by the environmental assessment work that's already been done? And of course, the logic of this, just to be clear, is whilst this is a longer tunnel extension, on my learned friend's construction, even a 10-metre extension of a tunnel is not going to be described or assessed in that 10-metre extension in the ES, because otherwise it would be part of the scheduled works, or a roundabout, or a cutting or a retaining wall, all of the things which Section 2 is enabling to be done. You'd be back at square one, in effect, if the effect of Section 22 was to remove planning permission, which you then have to get separate consent. Does that interpretation of the Section 20 cover by looking at, well, what is the environmental aid, comply with the purpose of the environmental legislation? We say absolutely it does. And that is what the judge concluded, but with some helpful reference to the case of Rochdale Council ex parte Mill, which you'll find at page 433 of the Bundle Authorities tab 10. And I appreciate the court's already been taken to that, so I'm not going to spend a lot of time going through all the paragraphs.
Sort of.
Oh, well, it's...
It was alluded to.
Alluded to. Well, let me...
Not an easy read.
No, it's not. Well, my lord, if I
share that.
well, can I just try and summarise it and just flag up the relevant paragraphs, which I hope will help. It was the second round, as identified, of litigation about an industrial park, a business park, I think, business park, where outline planning permission was being granted, and it was all about the application of the EIA regulations to outline planning permissions, which are, I think, peculiar concept of UK law, certainly England and Wales, but maybe other countries haven't. But it was engaging, I think, for the first time, the question of EIA compliance. In the first case, to which reference is made and is summarised by the judge at paragraphs 1 to 16, I don't need to flag them up, but in the first case, outline planning permission had been granted for the business park and an environmental statement or assessment undergone, but there was no restriction on the grant of planning permission which tied what could subsequently be developed to the illustrative master plan that had been used for the environmental statement. So an outline planning application gave an illustrative form of how this business park would be built in terms of disposition and height of buildings, etc. So they said they complied with ES, but the grant of planning permission didn't tie subsequent details for approval under outline to that illustrative master plan. And in a nutshell, that would mean a developer could come forward with something different from the illustrative master plan, which might have different likely significant environmental effects, which had never been assessed. I hope that helps.
Was that a mistake?
And that was deemed to be a mistake because it didn't secure for the grant of consent, the effects, the environmental effects with the permission.
But it's a clerical error or something of that.
No.
It was a conceptual
error. Yes,
error.
conceptual error, and it was addressed in second time around. In effect, by following the same process, you're still seeking an outline planning permission. As it happens, there was more detail fixed, but that's beside the point for the point of principle. Still an outline planning application in material terms, again an environmental assessment by reference to an illustrative master plan or development framework as it was known, and then a condition imposed on the planning permission which required development coming forward to be in substantial accordance with that development framework. And that was the cure accepted by the judge for compliance with the EIA regulations, because the developer, whilst having an outline consent, having some flexibility in the form and development of the disposition of the buildings in due course, still had to ensure it was in substantial accordance with what had been illustratively shown, so thereby guarding against the likely significant effects which might come from a different form of development. I hope that describes the case in a nutshell.
Right.
There's obviously a consideration given by the judge, and I'll just give you the references rather than take you the court through it. But the ground of challenge second time around was to say, well, that's still not compliant with the EIA directive because the reserve matters, those things which are for subsequent approval, include all sorts of things which could have likely significant
Well,
effects.
basically the challenge was, if you look at the legislation governing outline planning permissions, it was inconsistent with the EIA regulations.
Absolutely, because it was reserving matters, deferring matters, which could actually result in significant effects. For example, on heritage impacts.
Which should be assessed at the outset.
Which should be assessed and fixed and controlled at the outset. Exactly. So the judge rejected that by reference to some principles. The first of which is the flexibility that the legislations should show, and you can get a flavour of that. Paragraphs 83 and 80 to 85. Not to frustrate, this is not meant to be a mechanism frustrating development. It's about reasonable application, which we would say, yes, certainly, and that would apply to approving a railway in the national interest. And paragraph 89, not being unduly prescriptive in terms of description of development. Paragraph 90, recognising things may evolve. And paragraph 91, the legal straitjacket. Yes, a legal straitjacket, but not one intended to suffocate the wearer of it.
I mean, you see in 89 at the beginning that the description of the project is the starting point of the assessment process.
My lord, exactly.
But then he went on to add that these regs are applied to a wide range of different types of development, some of which are rather more specific in their intrinsic nature, some of which are more nebulous, yes, like a business park.
My lord, yes, and we have to be careful not to take the analogies too far. Here, the description of the project is a railway line from London to the West Midlands. That's why I talked about, well, what is the project here? It's the wider project. In the case of a business park, it's outline permission for a business park. As I indicated, there are all sorts of other works that could occur under the reserved matters. And it's a question of how you control them. And then paragraphs...
you should look at 90, because he gives the example of an industrial estate development, which will take place over many years and depend on market demand.
Oh, yes.
And what he says is that, he goes on to say in 90, is that an ES of that type of project should assess the environmental effect of flexibility.
My lord, yes, indeed. But as I said, there are different ways, I'm going to come to that, there are different ways of controlling this. In this particular case, the mechanism of control was a condition requiring to be a substantial accordance with what had been assessed.
Well, there's some other conditions as well, like heights of buildings and so on.
Parameters, yes.
There's a whole suite of conditions.
Yes, but as I understand it, the substantial accordance with the framework including, of course, proposed types of building.
Sorry.
Sorry.
The phrase environmental envelope has been...
Yes, so the...
trips off the tongue. Where does it
Yeah,
come
so the environmental envelope doesn't... I don't think it's expressed by the judge in this case as an envelope, but I might be wrong about that.
I think there is one somewhere.
Oh, is there one reference to it? I mean, as a result of this case, it's commonly referred to as the Rochdale envelope by environmental practitioners, namely after the case Rochdale.
Yes.
But I might be correct.
Well,
I don't think the judge refers
parameters at the bottom of page 384, 93.
Yes, I don't think I'm pretty sure the judge doesn't refer to it as an envelope, but that's the subsequent jargon, as it were, but the concept of the Rochdale envelope.
And it comes back again at the foot of page 384, the likely significant effects of such a flexible project, flexibility point.
Yes, absolutely. And 100, the description not having to be exhaustive, for example, the ability to ask for more information. Then there's a whole passage about evaluative judgment, which I don't need to trouble you with, that emphasising the evaluative judgment 104 through to 111. And then paragraph 113, there's recognition that the subsequent details may affect the development, but the regulations are only concerned with likely significant effects. And at 113 that I just referred you to, and indeed the analysis that follows, and detail sufficiently controlled by condition, and 116, the judge actually is specifically recognising that this isn't a procedure that precludes significant effects occurring later, but it's about exercising control over likely significant effects. And he gives the example.
Sorry, that's paragraph.
Starting at 113.
Yeah.
And I'll just turn it up. The example I've got in mind, sorry, I lost my page, is at 119. And then, if I could, I invite, obviously we need to read it as a whole, but 127 is an illustration of the point. It's true that at the reserved matters stage, the council might theoretically approve a building in a particularly shocking colour or with a particularly intrusive roof design. Just pausing there, those are things that have been left over, deferred. And in theory, yes, that could happen. Hence the effect, for example, of a rainbow-coloured building T or bizarre landmark building is not a likely effect, let alone a likely significant effect. And so, whilst there is flexibility and indeed deferral to an authority, the EIA process is not concerned with precluding, the legal straitjacket, precluding any determination or flexibility, but it's concerned with addressing likely significant effects. And you'll see 131 dealing with, for example, disposition of buildings within the business park. They have to be in substantial accordance with the framework, was the condition 1.7, which secured, so far as the judge was concerned, the ES against what was being consented. So I hope that helps understand, not the word envelope not used, but in effect, if you've got an ES, you're granting permission for something within that, I'm making shape as if it's an envelope or something. And I just want to touch on that in a moment. But provided you tie your subsequent consent to what you've assessed and what's likely, then it'll be compliant. Can I just want to a word of caution about the use of the word envelope, because an envelope suggests a three-dimensional restriction, say parameters. It's not always the case in environmental terms that an envelope is of that kind. If you take an example of giving consent for a building of up to 40 stories, which might be a common way to express the grant of consent, the environmental impact assessment will probably assess the impact of a 40-story building in terms of its landscape and visual effects, because that's the most visible it would be. But the permission allows you to build a 20-story building because on the basis that the landscape and visual effects are going to be of a lesser impact than the 40-story building. But it's not always the case that it works in that way. So, for example, an industrial premises with a chimney stack may have a landscape and visual impact of a 100-metre chimney, but if you built a lower chimney, in fact, you may have worse environmental impacts in terms of emissions. So it's not simply a landscape and visual effect in terms of height that's beneficial to reduce it. It may actually make it worse in terms of overall emissions if it's lower. So an environmental envelope doesn't mean physically it's always going to be in that same three dimensions. What it does mean is that your environmental envelope is effectively assessing for each discipline a realistic worst case for what you're proposing. That's also a terminology that appears in environmental assessment. What's the realistic worst case for the particular topic? It may be traffic generates road emissions, construction traffic, it may be lighting, it may be whatever, depending upon the topic. So just a word of caution about environmental envelopes always being sort of a restrictive parameter of heights, which is it's not always the case.
So in the present case, Mr. Hal Williams has putting it from the point of view of the inhabitants of Water Orton,
Yes.
that they're saying Parliament wasn't told that we were going to have 5 years of rather disagreeable and noisy and obtrusive works on our doorstep, which wouldn't have happened to us if the tunnel had been limited to a shorter distance.
Yes. My Lord, that's a very good example. I don't know the precise details of the construction timeline because they will be in the report. We can find them out for you. But that's exactly the sort of thing that was considered in whether or not what was being proposed has new or different likely significant effects to those which had already been assessed. And if, for example, as a result of mitigation measures to the construction site, because you know, because I've shown you there was a very substantial construction site there already, those measures involve mitigation of the construction effects, be it visual, be it noise, such you wouldn't experience them. You're either, the conclusion's either, we don't have the detail, the likely significant effects are effectively the same, the duration's not going to matter or not be treated as significant in itself as a result of mitigation, or you are already concluding, or there might have been some benefits between the differences of the works. So, for example, constructing earthworks, my Lord referred to earlier, sometimes can be noisier than a tunnelling machine. I don't know the detail, but the point about all of that is those were matters for the Secretaries of State to consider whether or not the likely significant effects that came with the original project were new or different ones, and that, I emphasise, new or different likely significant effects, not effects, were going to occur as a result of this proposal. And the Secretaries of State concluded there weren't. And if my learned friend says, well, it's obvious, it's unsurprising, but where is the evidence that it was obvious or surprising or that there was some error of approach in the Secretary of State's assessment of those matters by reference to the detailed report that was...
But that goes back to a point, as you said previously, which is not under challenge.
Exactly. But my Lord, that is what this challenge is ultimately boils down to, because unless it's wrong for the Secretary of State to ask that question, is this within the environmental envelope that's been originally assessed, which is what I submit covered by this saying. Unless that's a wrong approach, you can't attack the Secretary of State's decision absent a rationality challenge.
That's understood, but that comes back to a point of construction.
Well, let me then complete the picture on the point of construction, really. Section 22, subsection C, do the words covered by therefore mean, as I've submitted, that one is looking at the environmental envelope in the way the Secretaries of State did, namely comparing the effects, the likely significant effects of what was originally assessed with those which were now going to occur with the new development. And in my submission, for the reasons the judge has already given answer, yes, they do, but it's a deliberate use of the word covered by. And then in in section 68.4, the references to information in the ES. And that is part of the information. I mean, that is the information in the ES. Does it mean, as the council contend, no, you have to have identified in the ES the alternative of a longer tunnel? Answer, we say no. That's not what the words covered by mean. You could require that. It would go beyond, as I submit, the EIA regulations. If you use words like, is the particular new work assessed in the ES? But it doesn't say that. It says covered by. And importantly, we say that's entirely consistent with compliance with the EIA regulations and the concept of an environmental envelope and the concept of flexibility.
Well, can we just think about the Milne case as you were pointing out, is all about a development which is intrinsically of a flexible nature. It's going to be built out over 10 years according to market demand, as the judge explained.
Yes.
So what is happening in that case is that the compliance with the IA regime depends upon conditions which time what comes forward to what's been assessed at the outset.
Yes.
But what comes forward is within the scope of the planning permission. It's industrial development or office development, wherever it may be on the business.
Yes, my lord, agreed. And that is why I come back to section 20. What is coming forward here is within the scope of what is authorised by the Act under section 21, namely schedule works, or if not schedule works, they have to be worked within the Act limits, and they have to be for phase 1 purposes. So there's no question of doing them for something else. So you're already constrained in terms of your environmental envelope, as it were, the nature of the consent, by the mere fact that, yes, you could lower the railway, and as we say, you could put it in tunnel, but you could only do that on the line of route. You can only do it using land you already have. And true it is that the original ES won't have assessed in terms, I say in terms, as in the specific description of the tunnel extension, because it wasn't at that time being proposed. But that is the very purpose of section 2, with the limitations it imposes within Act limits, and the development consent being the construction of a railway, subject, of course, to the important point that you need to be within the environmental envelope of what has been assessed by way of likely significant effects. And if it were the case, for example, that the construction of the tunnel in this location were to have new likely significant effects, for example, on the noise of the residential amenity, or something unforeseen that only arises as a result of the tunnelling and constitutes a likely significant effect rather than an effect, then of course the judgment would go the other way.
Where do the words new or different, likely significant effects come from?
From the concept of cover by. I mean, they're used to describe, well, they're also actually, I think, reflected in what we've referred to as some of the material.
Well, it seems to be in the promoter's report on screening. They use the concept there.
My lord, yes, I wonder whether it also is reflected in the environmental minimum requirements. Yes, in the EMRs, and I was just going to give you some references to how those operate, the general principles document, page 97 of the supplementary bundle, the controls contained in the EMRs, along with the powers, etc., will ensure that the impact, I'm so sorry, page 97 of the supplementary bundle. Yes. My lord, my lady, paragraph 1.1.3 when you get there. It's not those exact words, not those words, it's any new impact or impact in excess of those assessed in the ES. And I think that's the language used in the environmental screening report I took you to earlier. Is it convenient just to, since we touched on the EMRs, could I just answer my Lord's question yesterday as to how those operate? The answer to that is that the environmental minimum requirements are the subject of an undertaking given by the Secretary of State to Parliament.
The undertaking
And-
is in the witness statement, isn't it?
It's referred to, yes. I've got two references for you. Page 129 of the bundle,
Of the supplemental bundle?
supplementary bundle, and page 130. 129 is a note that I think was attached to one of the information papers at the time that records how the undertaking was given. And then 100.
Sorry, where do we read?
I'm sorry. It's on the right-hand side of the page. Counsel for the promoter confirmed on day one of the committee proceedings they would be made contractually binding. Council also gave an undertaking to Parliament on behalf of the Secretary of State concerning their enforcement. And then you can see...
Sorry, where are you reading from?
I'm sorry, page 129 on the right-hand side of the page.
It's the italicised indented
Oh, I see, yes,
passage.
yes.
But it's provided, and I understand this has been done historically, both for Crossrail and HS1, but the Secretary of State or the promoting minister provides an undertaking to Parliament. And page 130...
Yeah, but sorry, it starts off by talking about insofar as not directly enforceable against any undertaker.
My Lord, yes, because...
Because, as I understand it, the contractual arrangements with the undertaker includes an obligation on the contractor's part to comply with the EMR.
Yes, so
that would be the first port of call.
That would be the first port of call. But because the Secretary of State will be contracting with people to build the railway, and the EMRs cover a whole host of matters, like the Code of Construction Practice, there's also an undertaking given by the Secretary of State to Parliament.
Not in the legislation.
Not in the legislation, but part of the enactment.
Not in the deemed consent, for example.
It's not in the, no, it's not in the deemed consent, but my Lord, it is nonetheless. And page 130 is a formal register of undertakings on the record. It's item 63, it's set out.
How are the undertakings enforceable?
By Parliament's
Parliament.
interaction with the Secretary of State, yes.
Yeah. And this is a qualified undertaking insofar as he considers reasonable and necessary. So it gives him quite a discretion.
Well, my Lord,
It's not a hard-edged undertaking that the EMR will be complied with.
my Lord, it's, all I have referred to for the EMRs, and your Lordship raised the question, is that's how the undertaking's given. And the only reason we've referred to the EMRs and the general principles is to reinforce, or as an interpretive aid, to the proper construction of section 20, subsection 2C, as to what the words covered by mean, and whether they...
Is there any authority which says we can take an undertaking like this into account in construing the words actually used by Parliament to express its intent?
My Lord, the EMR, the General Principles document that accompanies the bill as a statement on behalf of the Secretary of State, and at the time of promotion we submit, is a legitimate aid to construction.
But is there any authority on this?
I doubt it. I don't know. I haven't seen one. But I mean, I don't think this issue has cropped up before.
Potentially very interesting. This is completely different from public bills. From public bills, ordinary government bills, until Pepper and Hart weren't allowed even to refer to what the Minister had said, even if it was in the form of an undertaking. Since 1990, we've been scrabbling about, usually rather uselessly, in Hansard. But for hybrid or private bills, there's a register of undertaking.
Yes. And a lot of the petitions can be resolved in Parliament by the offer of an undertaking, which is then treated as a commitment on the part of the Secretary of State to comply with it. And of course, because this is a parliamentary process, the mechanism for enforcement is via Parliament. But my Lord, that's
not obvious what it would be, but anyway.
Well, I think it ultimately engages questions of compliance or contempt in relation to Parliament.
But it's not like, for example, a condition in a Milne planning permission
No, my lord, I'm not equating it to that, just to be clear.
No.
I said the mill condition is 1.7, we looked at that. I also made the submission that that's not the only way you secure compliance with the EIA regulations. You can secure compliance with the environmental load in a number of different ways. And one way you can do it is precisely the way it's done in this Act, which is to give you planning permission for everything authorised, but to say this exception is if you fail to meet those cumulative tests, you won't have planning permission. The last of which is, are your environmental effects covered by a previous report? And if they are, that's okay, because you're not then giving rise to new or different likely significant effects which haven't already been assessed. So, my lord, where the precise phraseology new and different likely comes from, it's certainly used in the Secretary of State's decision. Here it's expressed as any new impact in excess of the ES. For my part, the critical thing is that approach, looking for new or different or impacts in excess of what's already been assessed, compliant with the underlying purpose of the regulations? We say absolutely it is.
Well, since you raised that point, if you forget the Act for a moment and just think about a fairly straightforward development control situation,
Yes.
you might have a planning permission granted for a project, some form of commercial development, which is EIA development, and it's been subject to the EIA process. The
Yes.
decision's been granted. And then 5 years later, the owner of the land comes up with a different project, and it's decided that that is EIA development and requires EIA.
That's a new planning permission being sought.
Yes, indeed.
That's distinct from
Well,
here.
but you wouldn't be able to avoid the need for EIA by saying this is no worse than the environmental effects which were previously accepted.
My lord, that's because at that point one is granting consent for a different planning application.
Whereas unlike Milne, what comes forward subsequently is within the ambit of the original planning permission.
Yes, and in this Act, what's coming forward is not new development. We're deciding whether it's new development by reference to whether it does have new effects, because the original planning permission is in section 20, subsection 1. It's for the construction or the authorisation of all acts. You're taken outside that planning permission if you're not covered by the ES. And that you could impose that as a condition. I think they are imposed on development consent orders, for example, where there's power to carry out works, but provided they don't have new or different significant likely effects. But, my lord, that's just my recollection. But the point of principle is that that's compliant with the EIA regulations. No new planning permission has been granted here. The question is what you're doing within the scope of what's already been assessed? And that's how it operates.
But just standing back for a moment, coming back to the Act, in relation to ground 1, you say that section 2 enables substantially different works to come forward. It could be a tunnel where there's no tunnel previously proposed at all, or it could be a tunnel extension, and it could be for quite a distance. The constraint on what can be done is not so much in that part of section 2, because of the very broad language used at the outset. It is on limits of deviation, and then the constraint on the deemed planning permission.
Yes, section 20. Yes.
Section 20. And ultimately, it boils down to subparagraph C,
Yes.
and it depends upon the test you say that the Secretary of State adopted here.
Yes.
But in implying that test, it's necessary for the decision maker to consider the environmental effects of what is now proposed, which may be very different from what has previously been considered.
My lord, that's exactly what the Secretary of State did.
Yes, but isn't that tantamount to embarking upon an environmental assessment?
No, my lord, it's tantamount to establishing whether or not your effects fall within the environmental envelope of what's already been consented.
But in order to do that, to do it properly, you may have to go into the level of detail or similar level of detail which would be appropriate to an EIA.
The level of detail that's necessary is going to be obviously dependent on the characteristics and what was done previously. Hence, I come back to the fact.
But otherwise, what's the stopping point?
Well, my lord,
I appreciate your argument is, on the other hand, if we look at the council's argument, that it's capable of applying to relatively small changes. But if you look at your argument, it's capable of applying to very big changes, which is why I ask, what ultimately takes something like that outside Section 20 by reference to subparagraph C?
Yes, my lord, a number of things. I mean, I've already referred you to Section 2 itself. You need to be within the Act limits.
Yes, got that.
So you're already within the parameters of, as it were, of the scheme. There then needs to be. You can't do it for any other purpose. You can't build retail, etc., or go on a frolic of that kind. And then, so far as you're changing the project, yes, the test is it covered by, and the reach or the trigger point is if there's something new or different which hasn't been, the likely significant effect which hasn't already been assessed. And my lord, can I pick up on this judge and jury point? Because this is an important point for any principle. Here, HS2 took that view. They were not judge or jury.
Because it had to be looked at by somebody else.
It was looked at because the council challenged it.
Yeah.
And so it went to an inspector. The inspector expressed a view. The Secretary of State didn't agree with all of that view, partly on legal grounds and partly on, for example, tree cover of the works. But even then, the Secretary of State aren't judge and jury because the court below has the power on judicial review to check whether that has been done lawfully.
But in any event, there's nothing wrong with the Secretary of State judging the issue.
No, well, I mean, that would be commonplace. But
that's a different question to the one I've been asking you.
Well, my lord, the question, what's the limit? And the answer is,
without actually embarking upon something tantamount to an EIA.
Well, my lord, I don't accept it's tantamount because you don't.
An environmental statement.
Well, it's not tantamount in this sense because an EIA involves other things
well,
to go on, like consultation.
You phrased the question as ES, the first stage of the EIA.
Well, my lord, again, ES has to be an ES. Of course, the content of an ES is project specific.
Yeah.
So if you're talking about the procedural requirements for an ES, that's different. But if you're talking about the content, some ESs can be very focused depending on the nature of the development. Some can be very broad. But here, there was material for the Secretary of State provided by the interested party, actually a very detailed report. Whether or not it's tantamount to an ES, I mean, maybe the content is similar.
It involves assessing all the relevant, likely significant effects.
My lord, yes, but what's wrong with that? I mean, I ask rhetorically, because that therefore, and it's done as here, tested, and if someone's, that's the point I was making earlier, if someone says, well, you've left out something, or you misunderstood the nature of the development, or, where's the consideration of X, Y, Z, then that can all be raised first in front of the inspector, considered by the Secretary of State, and ultimately reviewed by the High Court if something's gone wrong in the process. But if your Lordship's question is directed to, is that process somehow at odds with the environmental impact assessment regulations? Answer, no, because you've already got your development consent and you're going on an exercise of establishing whether or not you're compliant with it. And after all, my lord, this isn't an equivalent, but just think about permitted development rights under Article 310 of the General Permitted Development Order.
These are planning permissions granted by statute.
By statutory instrument, where they've long pre-existed environmental impact assessment.
Yeah.
But they grant all sorts of permitted development rights, which can be quite substantial, agricultural or whatever, sometimes crown development. But they're now subject to a requirement under Article 310, I think it is, which is say those rights won't apply if there are likely significant effects in order to comply with the regulations. But that exercise
But
doesn't...
that's the test in section 22, paragraph A, the screening test.
Yes, my lord, it doesn't require one to carry out an ES or an EIA. It requires you to make a judgment which can then be challenged. There's no difference in that sense. It's sort of the cart before the horse to say I've got to do an EIA in order to decide whether or not I need an EIA. So that, as a process, there's nothing untoward about section 22C being answered. As to the degree of information, that's going to be fact sensitive and project specific, but no complaint is made here, or no legitimate complaint within the terms of the grounds of appeal or claim. I'm very conscious of the time, so I want to, those essentially are submissions as to why the correct test is one that focuses on the difference, new or difference, or assessment of impacts which haven't been assessed. That's what the Secretary of State did here, and thereafter it becomes a putative challenge on rationality grounds which hasn't been mounted. For those reasons, can I just turn and just to... We've got the 2011 regulations here.
I'm very grateful.
Can I hand those in?
Whenever it's convenient.
Unless I can assist the court further.
Mr. Corner.
Lord, I adopt what the submissions made by my little friend Mr. Strawn for the Secretaries of State on behalf of the interested party, and I seek to make the following points. I'll seek to make them concisely.
Yeah.
My Lord, in summary, we say, as do the Secretaries of State, the Respondents, that Section 20, the deemed planning permission in Section 20, covers the development that the Secretary of State was concerned with in their Secretaries of State were concerned with in their decision. My Lord, if I can just say a few words about the background. The background to Ground 2 is the flexibility recognised in the Act. I won't seek to go over this in detail, but as we've already seen, Schedule 1, Paragraph 1, subparagraph 2 specifies the limits of deviation laterally, upwards and downwards. And Section 2 gives further flexibility to go beyond the works identified in Schedule 1. As Mr. Justice Dove said in paragraph 34 of his judgment, which is in CB6 at page 44. So I'm on Mr. Justice Dove's judgment at paragraph 34, authority, core bundle, page 44. The provisions of section 2.1 are integral to the approach in Schedule 1, subparagraph 1, paragraph 1, of identifying what he called parameters and constrained flexibility to ensure that the project is delivered effectively. After all, deviations within the Act limits may well lead to the need for further changes. For example, Schedule 1, Paragraph 1 allows deviation downwards. That's quite likely to require earthworks, for example, embankments, and may also require a tunnel. This need for flexibility was recognised while the bill was going through Parliament. See, for example, Volume 1 of the ES. This is at Supplementary Bundle, page 48. Paragraph 1.3.5. I simply ask reference to that page, that part of the ES, just to illustrate the point that the need for flexibility was recognised during the passage of the bill. In this sense, the planning permission granted by the 2017 Act is akin to, it's not the same as, but it's akin to an outline planning permission. The design of the Phase 1 scheme provided the level of detail necessary for the purposes of the bill and the requirements of the EIA directive. And it was clear that the level of detailed design required to enable Phase 1 to be actually built was to be undertaken after enactment, after royal assent. Section 2.1, subsection 1, clearly allows for works that weren't anticipated when the bill was published and the Act enacted. Works outside Schedule 1, i.e. non-scheduled works, aren't described in the Act, of course. And therefore, they're unlikely to have been identified and specifically assessed in the ES. Had they been identified at the time, they'd no doubt have been made scheduled works, i.e. in Schedule 1.
Unless there was a wish for flexibility.
Yes. So we say the words in section 68, subsection 4, which tell us when development is covered by an environmental assessment in connection with the bill. Those words must refer to development whose effects fall within the environmental envelope considered in the ES. as opposed to it being required that the works themselves must be expressly assessed in the ES, which is what the Council appears to suggest. This interpretation, which is, of course, also the view that the Secretaries of State took, doesn't offend against the wording of Section 20, subsection 2, or Section 68, subsection 4. Section 68, subsection 4 doesn't require that development itself should be assessed in the ES. What is required instead is that information contained in the ES should constitute an ES in relation to that development. Information in the ES constitutes an ES in relation to the development that we're dealing with if the information in the ES covers the development's likely significant effects. And it will cover those effects if the environmental envelope assessed in the ES is sufficient to include the development proposed. As has already been said, the Rochdale concept of environmental envelope was well known when the bill was published. The Rochdale case, as you know, dates from 2000. And Mr. Justice Dove was quite right to say in paragraph 45 of his judgment, which is at page 47 of the four bundles, he was quite right to say that the 2017 Act is to be interpreted in the context of the EIA legislation and the relevant case law. And then, of course, in the following paragraph, and the following paragraphs, he refers to Rochdale. Acknowledging Rochdale as context for interpreting the 2017 Act accords with the principle that Parliament is presumed to be aware of the state of extant law, including case law, as per the case of Hirachand, to which your attention has already been drawn. Once the conclusion is reached that the respondents directed themselves correctly as to the law, it was a matter of judgment for them whether the proposed development fell within the environmental envelope. It's clear, and no one's contested it, that the respondent's judgment in a context, an environmental context such as this, can only be impugned on Wednesbury grounds. I don't think, the learned friend has cited some authority for that, but I don't think it needs to cite it. The appellant said in its skeleton, for example, at paragraphs 76 and 87. That the tunnel extension would in fact have likely significant effects beyond those assessed in the ES.
That's not a construction point.
No, it's not a construction.
It's not within the scope of the appeal of your simple submission.
Exactly. They made clear yesterday that they're not making a rationality challenge. And so they are simply not in a position to state that, to suggest that. They also appear in paragraph 89 of their skeleton to suggest that a full ES was needed before the Secretary of State could decide whether the works in question were within the environmental envelope of the ES submitted with the bill. As my learned friend has just said in response to a question from Lord Justice Holgate, not so. There's no requirement for an ES. The decision was for the Secretaries of State, the Respondents, and their decision can, as we know, only be impugned only on Wednesbury grounds, and there is no rationality challenge. It would be absurd to require an ES in order to decide whether a new ES is needed for the tunnel extension. The respondents entirely properly took into account the lengthy screening report by HS2. You've got extracts at supplementary bundle tab 19. You don't have tabs. I remind myself.
Not in the supplementary. Just give us it.
But it's at pages 156 to 216. I don't purport to take you to those pages now. The Secretaries of State, the Respondents, properly took into account the lengthy screening by HS2. You have, on my count, 60 pages of that report, pages 156 to 2016. But as Mr. Strawn said yesterday, you don't have chapters 4 to 18. So it was a very lengthy document. Also, as you heard yesterday from Mr. Strawn, the screening report was a three-stage process. One, considering the effects of the Phase 1 scheme as originally proposed. Two, assessing the effects of the amended scheme, which they call the proposed development. And three, comparing the effects of the Phase 1 scheme and the proposed development. The Secretaries of State were entitled to make their judgment on the basis of that screening report by my clients. But it's wholly wrong for the appellant to say that HS2 was judge and jury in its own cause. It was for, as has already been said, it was the Secretaries of State who took the decisions. It can't be said, and as I understand it hasn't been said, that it was wrong for the respondents to take account of HS2's screening report. Next, it was for the respondents to decide how to consider the approach that they would take to the question of the environmental envelope. It's clear from decision letter paragraph 13, which is at core bundle tab 10, page 141, that they looked at the effect of the tunnel extension project as a whole, as they were entitled.
Sorry, can you say that again? They looked at the effect
of the tunnel extension project as a whole.
What do you mean by as a whole?
Well, as the tunnel extension scheme as a whole.
The whole of the tunnel extension?
Yeah.
Yeah.
They were entitled to do that.
Not just the portal, but the whole extension.
Not just the whole.
Not just the portal, but the whole extension.
Yeah. Ms. Levy says in her second statement, can we just go to that? It's Ms. Levy's second witness statement is in the supplementary bundle at pages 42 to 46. And I'm looking at paragraph 11, which is on page 45. If my lady and your lordships have that, she says there, the claimant, that's the appellant now, acknowledges that across the entirety of the tunnel extension scheme, there are environmental benefits to be achieved. It's in terms of the effect on Water Orton that the claimant considers that the significant environmental effects exceed those reported in the environmental statement. But it was for the Secretaries of State, for the Respondents, to decide how to deal with the issue of the environmental envelope. And as I've said, it appears to me they did so by looking at the tunnel extension scheme as a whole, as they were entitled to do. Can I just deal briefly with the reference by the respondents in their decision to new or different, likely significant effects? This phrase does crop up in a number of paragraphs of the decision. I'm looking now at Core Bundle tab 10, pages 140 to 141. This phrase is used by the respondents at paragraphs, decision letter paragraphs 11, 12, and 19. 13, I think.
13, yeah.
I'm so sorry. Yeah. But it's clear that they were referring, that, I say, is a perfectly acceptable and ordinary way of referring to the concept of the environmental envelope. And indeed, if we look at decision letter paragraph 12 on page 140, we see in the third sentence the statement, the EMRs state that the intention of the provisions of the HS2 Act and the EMRs is to ensure that impacts which have been assessed in the ES will not be exceeded. It goes on to say, Secretaries of State therefore consider that development where there are no new or different likely significant effects to those reported in the ES can fall within subsection 2C. So it's quite plain they were considering, and considering properly, the concept of the environmental envelope. Can I just deal with the statement in the ES that the tunnel extension was not going to be brought forward in the proposed scheme? That statement is at supplementary bundle, page 59. For those who have tabs, it's tab 7. And of course, I'm looking at paragraph 2.6.18. The potential for a longer tunnel has not been included in the proposed scheme. As Mr. Strawn said yesterday, it's plain from that paragraph that a longer tunnel extension was considered. It was decided at that stage not to proceed with it, but later it was decided to proceed with it. And the question is whether the environmental envelope in the ES is sufficient to include the longer tunnel. That could be so, even if the ES did not expressly cover the longer tunnel, but it did, of course. Next, I'd like to go back to the appellant's skeleton argument, if I may. And I'm looking at paragraph 69. This is at the foot of page 201 of the core bundle. And the appellant says here, it was in effect common ground between the parties before the inspector, that's the appellant and my clients, that as the as yet unconsented BTA and therefore the BTEP and associated works were not considered during the passage of the HS2 bill through Parliament, being subsequent change to the scheme considered by Parliament, they are not covered by an environmental assessment in connection with the bill.
That's not common ground.
Pardon?
That's not common.
No.
There should be a full stop after considered by Parliament,
Yes.
and then new sentence, or we submit that.
Well, exactly.
Yeah.
HS2, just to be clear, accepted only at the hearing before the inspector that the tunnel extension wasn't expressly assessed in the ES. But my client is recording in the inspector's report at IR 28, which is at CB tab 12, page 153. My client is recorded as saying that. This is the inspector recording my client's case as saying that the halfway down the paragraph, it is considered that the it is considered that the BTE would benefit from the DPP deemed planning permission because it would not have significant effects on the environment and would be development that was covered by the environmental assessment undertaken in connection with the bill that preceded the HS2 Act. A wrong reference is given there, but the point is made. So let it not be thought that my clients accepted at the hearing before the inspector that the council's case, the appellant's case, was correct. Just finally, if I may, in relation to the Secretary of State's screening decision of the 31st of March 2021, this is at supplementary bundle, page 226. Much reliance was placed by the appellant during yesterday's hearing on this letter. But as Mr. Justice Dove said at paragraphs 61 and 62 of his judgment, which are CB tab 6, pages 52 to 53, this doesn't help the appellant. All the Secretary of State was saying in that letter was that taken in isolation, the development which is now proposed would have significant environmental effects. And it's noteworthy that the Secretary of State added, this is page 227, in the last paragraph, the proposed changes to the project are likely to have significant effects on the environment, bracket, even if these are no greater than those previously assessed. The point under section 20, subsection 2, paragraph C, is that the Secretaries of State, the Respondents, properly considered that the development now proposed is within the environmental envelope of the ES that was deposited at the time of the bill, and therefore that its effects were no greater, in the words of this letter, than those previously assessed. I'm conscious of the time. I don't want to detain you at great length. Unless
It's
I
a
can
pleasure
assist
to
you
listen to
further,
you, Mr.
those
Corner.
are the submissions
We'll see if
I seek to make.
any other questions. Right. Thank you very much. My apologies to both juniors for the respondents not calling on you, but you didn't make a move, so thank you. Mr. Hal Williams or Miss Ollie, I imagine you would like a little more than 7 minutes.
My lord, I have 11 points. That may be pretty wrong, my lady, but I've got 11 so far, on a page and a quarter of A4. I'm very happy to make the reply now. Whatever.
Shall we do that? Yes. Right. See how you go.
Grateful. So my first point is that round 2 is actually quite straightforward in my submission. My second point is that, again in my submission, there can be no real dispute about what sections 22A and 22C mean, nor about section 68(4), but obviously the right question must be asked in a decision. Point 3, the single straightforward question to be asked under section 22C, in accordance with section 68(4), is there in the ES information on the development, and we've been saying development that satisfied regulation 18.3 of the current EIA regs. I don't think anybody's actually thought through, remarkably, the fact, until raised by my Lord Justice Holgate, that of course it was the 2011 regulations that applied. It's remarkable that no one has, so that's what collectively apologise. We have put them before you. So I'm not quite sure where that leaves us in terms of potentially Secretary of State or whoever making a decision about EIA matters that don't reflect how the law has evolved. I haven't thought that through yet.
I don't think there's any suggestions of material difference so far between the two sets of regulations. If anyone thinks that there is, then
okay, I'm grateful. I know, so I think Schedule 4 and Regulation 22. But I think we have to accept that we should have put those before the court. In any case, back to the single straightforward question, is there information on the development? Key submission here I'd like to make still on point 3. There is no evaluative judgment required by section 22C. Now, there might be under section 22A, but not under section 22C. So in my submission, there's no wriggling out of that. It's a question of fact. So it's no good trying to effectively get this court to deduce what the likely significant effects might be or to guess at what they are. There is no substitute for them actually having been assessed where that's required.
so I'm not understanding. You're saying subparagraph C doesn't require an evaluative judgment.
That is not an evaluative
of
judgment.
the effects. And then you went on to say something which sounded different.
Well, no, I was just backing that up by well, it's a simple submission. That question is a question of fact. So there's no room for making a judgment about it. It's just, is it there or is it not?
Well,
I'll come on to.
So you say not covered by means not expressly mentioned in.
No, my lord, I don't mean that. I'm not saying that it has to be rigidly assessed and anticipated in advance. So, however, how one wants to answer the question, is it covered, and how it comes within the envelope, fine. I'll come on to why that doesn't help us in this case. But it's not an evaluative judgment. It's just a simple question of does it come within or not. And obviously that takes.
Well, you're saying, putting it another way, it doesn't require an assessment, an environmental impact assessment for example.
Yeah, that particular question isn't about doing assessment. It
doesn't require that to be done if it hasn't been done already. It's asking, has it been done?
Yes.
If effectively.
Yes, I think that's what I'm saying. Yes. So, and then what I went on to say was, it's no good us looking at the material now, and I appreciate that we all have. And Ms. Levy's expressed a view about it, and I think that has its place. But it's not about this court saying, oh, well, of course there wouldn't be any more likely significant effects, or new or different, or whatever. It's just, we look to the ES. My fourth point is that both the Secretary of State and the learned judge went wrong. And so then I would move on to how they did in my submission. So, point 5. I don't think I'm going to need to go beyond the core bundle. I would like to just pop into the inspector's report and the learned judge's judgment. I would like to do so at this point. So for my point 5, the inspector's report, paragraph 12 of the decision. And sorry, my lord, page 140 to 141 of the core bundle. And the last sentence of paragraph 12, before we get to paragraph 13, when read in their proper context, sections 22C and 68(4 of the Act should be regarded as bringing within the ambit of the deemed planning permission those works which would not result in new or different likely significant effects to those assessed in the environmental statement. But the problem with the decision is that they don't then actually look at the environmental statement to answer the question. And I say that the question can't be answered without doing that. And that is the key to this case. And so the decision letter should have taken the matter in stages, simply following the way that section 20 is set out. We touched yesterday on this wording of new or different, because it's not actually part of the Act or the EIA general law. Section 20A 22A does refer to likely significant effects and not new or different. So that's a device of the Secretary of State to answer the question as a whole. So that's what the decision has done, and why that is wrong in law in my submission. And my point 6 was why to explain why the learned judge also went wrong, if I may. Because in his judgment, paragraph 62, and the last 5 lines of that, that's page 53 of the core bundle, paragraph 62. The learned judge doesn't consider the statutory question against the deposited environmental statement either. So obviously assuming the court is with me that it's a question of fact rather than evaluation, assuming that, then we see here that the learned judge has got it wrong, because he says, overall the short point is that the question which the defendants had to answer, once they'd properly understood the test required by section 22C, was one of evaluative judgment. And we might disagree, but that's the not in public law basis of challenge, not a basis of challenge in public law. So he's finding it was one of evaluative judgment, and I say that's wrong, that's a misunderstanding of the test, it's gone wrong in law. If one was to amalgamate the stages, then I suppose we would import an evaluative judgment, but that's the key part of the problem. So point 7, so asking the question of fact, which I say needs to be identified. What do we see, as a matter of fact, when we look at the environmental statement Obviously, that has to be in the context of the principles established or reflected in Milne. I take my Lord Justice Bean's point there. Milne, of course, is dealing with evolving detail, reserved matters, and wasn't a change to the development as such. I'll just put that in as an aside. So to answer the question of fact, is the development covered? No, it is not. We don't have the necessary information now required by Regulation 18.3. Point 8, why don't we? Answer, for the very simple reason that the chosen engineering solution was expressly discounted at the relevant time. And what that means is the tunnel extension can't be within any envelope, no matter what the dimension of the particular envelope one conceives of, because it was contemplated as an alternative but excluded. Point 9, if there was the necessary information, I'm sure this court would expect the respondents easily to be able to point to it. And as I perceive what I've heard, maybe different to what the court perceives, they cannot. Despite all that's been said, we've had a theoretical position put forward rather than a specific pointing to this is why it's satisfied in this case, this is looked at, therefore this proposed development is covered. At point 10, on the facts, obviously you've seen in paragraph 13 of the European decision, the Secretaries of State relied on the screening request from February 2021. It's clear that that's what the Secretaries of State have based their decision on. They conclude there'll be no new or different likely significant effects because they say accordingly. And I complained yesterday they don't deal with the 31st of March decision, which I submit couldn't be clearer in what it finds. So my final point, 11 then, subject to any questions I could assist with, is that the respondents answered the wrong question. And perhaps that's not surprising because the decision letter doesn't take the matter in 3 stages as required by section 20, subsection 2. And that's what I would like to say in reply.
Yes. Right, thank you. Mr. Corner.
My Lord, I'm conscious that we have 2 more notes for you that you asked for yesterday. There's a note on the right to be heard and not standby challenges, and the note on the High Speed Rail London West Midlands Bill and who was petitioning. Can I ask the appellant, have you looked at our notes and draft notes? Do you agree them?
I have, whilst other people have been talking, Mr. Corner, had the opportunity only to glance at the documents. Perhaps the best way forward is for us to be given the luncheon adjournment to look at those notes and to indicate to the court whether we've got any further comments to make. I'm reasonably confident that we won't have any further comments on the basis only of the glances and glimpses that I've had the opportunity to take so far. Like the court, I was only given them at about 10:25.
Well, we've done our best.
I'm not making any criticism of that. It's
Not critical
an explanation of why I haven't looked at them.
Yes.
So, are you proposing, Craig, if I can call you that, that I hand these notes up to the court?
Yes.
Okay, thank you very much.
Just a minute.
If not, we don't want them.
Thank you very much.
I think we've reached the stage where we should only receive this if there's no objection to it. So would you have we won't come back at 2:05 simply to be handed a document or not. Could you and Miss Ollie have a look at it, Mr. Howell Williams, in the next hour or so? If you have no objection to our receiving it, could Mr. Corner's clerks or somebody arrange for the documents to be sent to us But if you say no, then we don't want them.
That's fine. So I'll take them back.
Sorry, that was my fault.
Thank you very much.
Excess of practicality on my part.
Yes. How you get them to us, I'm sure is within your customary ingenuity. Thank you all very much for your submissions, both oral and written. I will be less than astonished to learn that we reserve judgment. As you know, the current procedure is when a judgment is ready in draft, it will be sent out to the parties, not for re-argument, but for correction of any typos, factual errors, dates and so forth. Once that's been done, the judgment will be formally handed down by being published on the National Archive website. The contents of the judgment are confidential until the formal promulgation, confidential in the sense that those who need to know within North Warwickshire or the departments or HS2 in order to be able to give instructions are allowed to see it, but it shouldn't be generally published. I think that covers everything. Thank you all very much.
What rise in favour?